You know that feeling when you're facing a whole stack of regulations,
Yeah.
trying to figure out exactly what applies to you.
Yeah, what you need to do, what happens if something goes wrong.
Yeah, exactly. And the info feels like it's scattered everywhere. It's like, where's the shortcut?
Mm-hmm. Getting those essential insights quickly is key.
Well, that's precisely what we're aiming for in today's deep dive. We're uh, cutting through some complex proposed changes, big ones.
That's right. We're diving into a new consultation paper. This one's from the Registration Authority of the RA over at the Abu Dhabi Global Market, ADGM.
Okay.
And this paper, well, it lays out some proposed new administrative regulations. It's all about how the RA enforces ADGM's commercial laws.
So things like investigations, procedures, sanctions, that kind of thing.
Exactly that. Modernizing and centralizing the whole enforcement process.
Okay, so our mission here is to really unpack this paper, break down the main proposals.
Figure out why they're suggesting these changes.
Yeah. The motivation behind it all, yeah. And crucially, what it might mean for you if you're operating within that ADGM framework.
It's about aiming for, a clearer, more predictable, and hopefully more effective enforcement landscape.
Okay, let's unpack this. So first things first, why the change? Why now? What's wrong with the current setup?
Well, the paper points out a pretty fundamental challenge. Right now, the RA's enforcement procedures, they aren't all in one neat place. They're kind of scattered across different pieces of commercial legislation within ADGM.
So you might have to juggle several different rule books just to get the full picture for one situation.
Precisely. And that fragmentation, well, it naturally opens the door to potential inconsistencies, makes it harder for everyone to, navigate the rules clearly.
Okay.
And another big issue they flag is this one-size-fits-all approach in the current process.
What do you mean by that?
It means whether it's something pretty minor or something quite serious, the same basic and often quite time-consuming procedural steps tend to apply.
Huh. So, like, filing something a bit late might trigger a similar kind of procedural burden as a much more serious breach. That's inefficient.
It can be, definitely for those minor things. The paper also mentions that some of the existing fines, maybe they're not seen as enough of a deterrent anymore.
Especially for the bigger stuff.
Yeah, particularly for more serious or maybe repeat contraventions, especially when you compare them to the maximum fines actually allowed under the main ADGM law.
Gotcha.
And there's another gap they identified, a lack of a clear statutory emergency process.
Meaning?
Meaning, if the RJON needs to move really fast, like urgently suspend a license because of serious concerns.
Right.
They don't currently have a specific, quick statutory path to do that outside the usual, sometimes slower procedure.
Okay. So for someone like you working in the ADGM, the system now could feel a bit disjointed, maybe inconsistent, cumbersome for small stuff, maybe too slow for urgent risks.
That sums it up pretty well, and these proposals are really aiming to tackle those issues directly.
So how are they proposing to fix that fragmentation, that inconsistency? What's the core idea?
The main proposal is to bring in these new standalone admin regulations.
Okay.
Think of it like a dedicated overarching rulebook just for enforcement procedures, investigations, all that related admin stuff.
Ah, like pulling all those scattered pages into one central manual.
That's basically the idea, yeah. So instead of each commercial law trying to detail its own enforcement steps.
They just point to this one central regulation.
Exactly. They just cross-refer to these new admin regulations. The aim is clarity, certainty, consistency, one reference point for how enforcement works across the board.
Makes sense.
And it should make future updates easier, too. You just amend the admin regs, and the changes flow through.
That does sound like a logical way to simplify things.
Ah.
Okay, let's get into the details then. What are some of the key changes and new features in these proposed regulations?
Well, a pretty major one is an updated fine scale, financial penalties. The paper says they did a comprehensive review of the current fine structure, and the proposal is to introduce a new, higher maximum level. They're calling it Level 9.
Level 9, and that's meant for?
It's specifically designed for the most serious contraventions, to act as a much stronger deterrent and also to align with the maximum fine allowed under the ADGM's founding law itself.
So the potential financial hit for really serious breaches could go up quite a bit.
Potentially, yes, right up to that maximum limit set in the main law. They also propose giving the RA clear power to increase the fine level if someone repeats the same offense.
Okay, so that adds some teeth. encourages fixing the problem rather than just paying repeated small fines.
Exactly. It's about encouraging sustained compliance. And it's not just about fines. The paper also proposes a comprehensive, sort of consolidated list of administrative sanctions the RA can use.
Beyond just money penalties.
Right. It gives the RA more discretion to pick the most appropriate response for a given case, rather than being limited by what's mentioned in scattered laws.
So what kind of sanctions are we talking about? What's on this list?
Well, the examples given include things like public censure, naming, and shaming, essentially. Financial penalties, obviously. Prohibition orders.
Which would stop someone doing certain things.
Yeah, stop someone acting in a specific role or capacity within ADGM. Also, enforceable undertakings. Those are like legally binding promises to do or not do certain things.
Okay.
And direct actions against licenses. Things like suspending a license, withdrawing it, canceling it, maybe putting restrictions on what activities it covers. It's a fairly broad toolkit.
Okay, here's where it gets really interesting. You mentioned earlier they wanted to tackle that one-size-fits-all problem. How does the proposal differentiate procedures?
Right, this is a really core part of it. They're proposing a two-tiered system for procedural fairness.
Two tiers.
Yeah, designed to streamline things for the less serious stuff, while keeping robust procedures for the significant contraventions.
Okay, break down Tier 1 for us. What falls into that, and what's the process like?
So Tier 1 is generally for the minor contraventions. Think things linked to the lower fine levels, like Level 1 and Level 2, often things like late filings, maybe minor administrative errors.
Right, the less serious stuff.
Exactly. And the process is meant to be much more efficient. It kicks off with the RA issuing a financial penalty notice.
Okay, clear notification of the penalty.
Yep. And then you, the recipient, would have a set period. They're proposing 28 days from getting that notice to submit what's called a statement of representations.
Which is basically your chance to respond.
Exactly. Your formal written response. You can argue your case, provide evidence, explain circumstances, maybe argue the fine is wrong or should be lower.
And the RA reviews that.
Yes. The RA reviews your submission and then responds, saying whether they're going to revoke the fine, reduce it, or uphold it based on what you've presented.
What if you're still not happy with the RA's final call on a Tier 1 fine?
Well, the option of judicial review by the ADGM courts is still there. Any final decision to impose a fine is an administrative action, so it can be challenged in court.
Got it. And I heard something about an incentive for quick resolution in Tier 1.
You did. That's a key proposal, a 30% discount on the Tier 1 financial penalty.
A 30% discount. How does that work?
If you accept the fine and pay it within 14 days of receiving that initial financial penalty notice.
Ah, okay. So that provides a clear incentive for you to quickly resolve minor compliance slips if you accept the penalty. Saves time and costs for everyone involved, potentially.
That seems to be the idea. Now, Tier 2, this is for the more serious stuff.
Right. The higher fines, levels 3 up to that new level 9, potentially $54 million.
Right.
Plus those other sanctions like prohibition orders or license actions.
Correct. And because the stakes are higher, the procedure here is more detailed, more formal.
How does it start?
It typically starts with a warning notice. This comes from someone called a decision maker.
A specific role within the RA.
Yes, an appointed official responsible for making these more complex enforcement decisions. The warning notice basically outlines the proposed enforcement action and the reasons for it.
So it gives you formal notice of what the RA is thinking and why.
Precisely. Then you get a period. The proposal is 14 days to submit your statement of representations. Again, your formal written response.
Your chance to argue your case, provide evidence.
Exactly. Address the points in the warning notice. After the decision maker considers your representations, they issue either a decision notice, which confirms changes or upholds the action, or maybe a discontinuation notice if they decide not to proceed after all.
Okay, so this Tier 2 process, it's clearly designed for more significant matters.
Yeah.
More formal steps, more detailed engagement before a final decision. It definitely splits the process compared to Tier 1.
It really aims to match the level of procedural rigor to the seriousness of the issue. And flowing from this Tier 2 structure, there's another interesting proposal. A formal way for a party to waive their procedural rights.
Waive rights, like the right to make representations or go to court. Why would you do that?
It's proposed as an option specifically if you accept liability for a Tier 2 contravention. You could agree in writing to the enforcement action the RA is proposing and formally waive those Tier 2 procedural rights, the representation stage, maybe even the right to judicial review, basically, to admit liability and get the matter resolved more quickly.
So it's a formal path if you just want to acknowledge the issue and settle it fast.
Precisely. It creates a clear mechanism for that kind of scenario where the facts aren't really in dispute. Now, another quite significant new power being proposed, the RACEO exceptional powers.
That sounds serious. High-stakes situations.
Very much so. This is intended as a statutory emergency power, reserved specifically for the RACEO. It can't be delegated.
Okay.
And it's meant for cases of genuinely exceptional urgency, where immediate action is vital to protect, say, market integrity or public interest.
Like needing to suspend a license instantly. Or stop some activity right away.
Exactly, that kind of thing. In those rare, urgent situations, the CEO could issue what's called an exceptional notice.
And that lets them...
It lets them take immediate action, like canceling, suspending, or restricting a license, maybe issuing a prohibition order, without having to go through the normal Tier 2 procedure first.
Wow. That's a significant power for urgent cases. Are there safeguards or potential concerns you might see about that kind of rapid decision-making power?
Well, the paper stresses it's for truly urgent, exceptional cases. And critically, even though the action is immediate, the affected party doesn't lose all rights.
Okay.
After the exceptional notice is issued, you still have the right to submit representations to the CEO, explaining your side. And crucially, you still have the right to take the matter to the ADGM courts for review.
Ah, I see. So it bypasses the initial procedure for speed, but the downstream checks and balances, the avenues for challenge, they're still there.
Exactly. That context is important. It looks like a necessary tool for extreme situations, but with those subsequent review rights built in.
Okay. What else is in the mix? Any other key proposals?
They also proposed putting a formal statutory settlement process into the regulations.
A settlement process. Don't they do settlements now?
They do, but the framework for it is currently more outlined in their internal manuals, like the DPDEM, rather than being an explicit power in the general regulations.
So this makes it official, statutory.
Yes. It introduces a clear statutory power, allowing the RA to enter into legally binding settlement agreements for Tier 2 contraventions at any point in the process. Formalizes it.
Provides a clear legal basis for reaching settlements instead of going through the full enforcement process every time.
Right. And one last thing mentioned is a proposal to introduce a statutory time limit.
The time limit on what?
On the RA's ability to actually start enforcement action for a contravention.
Ah, so putting some kind of boundary on how long after something happens the RA can pursue it, like a statute of limitations?
Something like that, yes. It aligns with general principles of procedural fairness and adds another layer of certainty for people subject to the rules.
Okay, so that's a lot of proposed changes. But let's be clear, these are still proposals, right? This isn't final yet.
Absolutely correct. This is all laid out in a public consultation paper. It's out there for feedback.
And who are they looking for feedback from?
Well, it's primarily aimed at the stakeholders directly subject to ADGM commercial laws. So licensed persons, other persons in ADGM, like directors, officers, auditors, that sort of group. But the paper explicitly says feedback is welcome from all interested stakeholders, anyone with a view.
And there's a deadline to get comments in.
There is. The consultation is open until July 17th, 2025.
July 17th. And how can people submit their thoughts?
Comments need to be sent in writing. There's an email address in the paper, raia.consultation@adgm.com.
akari.consultation@adgm.com.
Okay. And they do note that comments backed up by clear reasoning, maybe some evidence, will carry more weight. They also mention comments might be published unless you specifically ask for confidentiality.
Right. So if you have relevant experience or insights, maybe based on working within ADDM's framework, this is your chance to potentially shape how these final regulations look.
Definitely. It's a standard but important part of how regulations get developed.
Okay, so let's just recap the main goal here. These proposals are fundamentally about modernizing, centralizing ADGM's commercial enforcement, trying to get more clarity, consistency, efficiency.
And stronger deterrence where needed, yes.
And the key tools are things like that single overarching admin regulation.
The two-tiered system splitting minor and serious issues.
The updated fines, including that new level 9.
Those specific statutory powers, like the CEO's exceptional authority for emergencies.
And formalizing things like the settlement process.
Got it. And for you, if you're operating in or dealing with the ADGM, understanding these potential changes is really quite important.
Because
they're designed to make the processes you might encounter clearer, to make the potential consequences more predictable, and to handle minor stuff differently, more efficiently than the really serious breaches.
it definitely sounds like a significant potential shift in how enforcement might work day-to-day within the ADGM.
It does seem like it. It's an attempt, really, to balance things. You need effective deterrence. You need the ability to act decisively when necessary.
Right.
But you also need clear procedures and fairness for everyone involved. It's about finding that balance.
So maybe a final thought for you listening. As you consider these proposals, think about that balance they're trying to strike. How much efficiency is gained perhaps from that tiered system or the CEO's emergency powers? And how does that weigh against the detailed procedural rights, like in Tier 2, or the review options that remain? And maybe, with potentially higher stakes for serious issues, how might this shape compliance thinking and risk assessment inside ADGM if these changes go through? Something to mull over.